Now we consider one of the more frustrating and difficult set of issues from the law of contracts, and that's the rights of parties that are not part of a contract. So here we are talking about third-party beneficiaries, and we're talking about assignment and delegation and the resulting relationships that arise. So here, let's start with a hypothetical that gives rise to third-party beneficiary issues. Suppose we've got a pleasant residential neighborhood, and one house in that neighborhood is a lot more run down than the others. And that house contains a couple of old folks who haven't been able to maintain their home very well. And let's suppose that their kids decide to fix up their house for them. So the children of the owners of the house contract with a contractor to fix up that house. So the contract is between the kids and the contractor. The owners of the old rundown house are intended third-party beneficiaries of the contract between the kids and the contractor. So far, so good, right? We've got a straight third-party beneficiary situation where the old folks in the rundown house are the intended third-party beneficiaries of a contract between the homeowner's children and the contractor. Now, let's consider the rest of the neighborhood. The whole neighborhood is going to be benefited by having the one rundown house in the neighborhood all fixed up. The other folks in the neighborhood, let's focus on the neighbors of the rundown house. Those are the folks who probably will be most directly benefited by the house being fixed up. That is, apart from the people who actually live in the rundown house. Now, the neighbors are certainly going to be beneficiaries of the contract between the contractor and the kids. But they are not intended beneficiaries. They don't have any rights under the contract, whereas the old folks in the rundown house do. Intended third-party beneficiaries have got rights under a contract that they are not a party to. Unintended third-party beneficiaries do not. And that's really all you need to know. That's the core of the material on third-party beneficiaries. Intended third-party bennies have got rights. Unintended third-party bennies don't. That's it. Now, it sounds a lot more simple than it really is when you do multi-state practice. This is an area where the multi-state questions are really quite difficult. Personally, I find the third-party beneficiary contracts questions to be among the most difficult on the bar exam. But that's just me. Some of my students over the years actually find the stuff to be fairly easy. So I counsel you, go forth and practice. You'll find that on the essays, this material really is quite straightforward. We'll wind up with a plaintiff, almost always a plaintiff, who is not a party to a contract that he or she is trying to sue under. If that party who is the plaintiff is an intended third-party beneficiary, they may very well have rights that can be adjudicated under a third-party beneficiary contract theory. If we've got an unintended third-party beneficiary, they're not going to have rights under the contract. They may have rights under the laws of torts or real property, but not under the law of contracts. And as you go through and practice a lot of hypos, you're going to find that these issues are not that uncommonly tested. As always is the case on essays from any subject, what you need to focus on is the relationships between the parties. A third-party beneficiary will arise in a question, either on the essays or on the multi-state, almost always as a plaintiff. And so you have to come up with the plaintiff's theory of liability. If the plaintiff is not a party to a contract and the plaintiff wants to assert rights under that contract, really the only way they can do so is as an intended third-party beneficiary, unless they are a party that has been assigned or delegated rights under a contract. And then, although they won't be parties to the original contract, they will have to some extent stepped into the shoes of somebody else that's already been in a contract. So, as we consider the ideas of assignment and delegation, it's worth being aware of the fact that in the event of an assignment, depending on the relationships between the parties, an assignment may create a third-party beneficiary. But when we look at a delegation of duties will always create a third-party beneficiary just because of the relationships among the parties. So, as we consider these issues of assignment and delegation, remember that an assignee takes the contract with the same defenses that the assignor had. An assignee, someone who receives rights under an assignment, has got all of the rights that the party that assigned the deal also had. So there's a change in person, but there's no change in contractual rights. And one final detail with regard to assignment and delegation under the UCC. Remember that under the UCC, the benefits of a UCC contract are assignable even when the contract's terms say that they are not. And once again, with regard to the UCC, especially among merchants, what we as a society have tried to do is streamline the transactions, make the deals easier to enter into, easier to break, and we prefer damages as the remedy. So, that's all I've got to tell you in this format about third-party beneficiaries and assignments and delegation. We'll see a few of these issues in our practice together, and you will certainly see them as you go through multi-state practice. But there's one other area of contract law that I want to touch on in this video, and it is one that causes, I think, an unreasonable amount of anxiety among students, and that's the issue of conditions. Conditions. Now, I am addressing conditions the same way the National Conference of Bar Examiners does, as their own little separate area. That's not really how I think of them myself. I think of conditions really as being part of the substance of the contract. So I don't really think of conditions this far down the outline. I think of conditions as I am trying to first establish the contract, and probably more importantly, as I'm trying to interpret the terms that are in a contract. So, with regard to conditions, it is a little tempting to spend too much time studying this material. As you look at an outline, or even worse, if you look at a horn book, you'll see that the law of conditions is extremely elaborate and complicated. But if you do the practical thing and study the way this material is tested, you'll see that, in fact, the law of conditions is really quite straightforward. And as you examine the issues that are presented in any given fact pattern, what's really going on is this. The first issue with regard to any given condition is it a part of the contract? And if the answer is yes, the next question is, does it apply against the party that we are seeking to charge with compliance of the condition? And then, assuming it does, the next issue is, has the party satisfied the condition? And if the answer is no, then we have to consider what the consequences of that failure are. Is the consequence of the failure to meet a condition going to result in the breach of a contract, or is it going to be something else? Now, looking at the outline, we see that conditions fall into a few different categories. The big two are express conditions and constructive conditions, which I think you'll also see in some places as implied conditions. Express versus constructive conditions. Well, express conditions are easy because they'll be there in black and white, and all we've got to do is, as we interpret the contract as a whole, determine whether or not the conditions are part of the contract. Often they will be, and when they aren't, usually it will be a fairly easy fact that will trigger your analysis. But with regard to constructive conditions, here it can become quite elaborate. But I suggest that the constructive or the implied conditions boil down to a couple of big issues. With regard to constructive conditions, a big issue is if a constructive condition is not met, how serious a breach of contract is it? Now, breach and defenses to breach are the subjects of the next video in this series. But where we have the breach of really any condition, express or constructive, the issue becomes how serious a breach is it? And as we'll see in the next video, the seriousness of the breach is relevant to the remedies that will be available to the non-breaching party. So I think it is worth keeping in mind that there is one condition that is implied into every agreement, and that is the obligation of good faith and fair dealing. Now, it's worth keeping in mind that not all breaches of contract are acts of bad faith. Some are, but often they are not. The implied condition of good faith and fair dealing is basically another area where the law of contracts touches the law of torts. Because for a mere breach of contract, no punitive damages are available. But where a party engages in bad faith conduct, where a party deliberately does things more serious than merely breaching a contract, where a party engages in material misrepresentations, either ones that are good enough to establish fraud or others that are not quite fraudulent, but still enough to show indicia of bad faith. Here, a plaintiff who can show a breach of the implied covenant of good faith and fair dealing has got a decent shot at punitive damages. Where a contract is breached, only compensatory damages are available. But where there is bad faith or fraud, a successful plaintiff is entitled to shoot for punitive damages. And I think intuitively all of us know that the more serious the breach of bad faith, the more likely punitive damages will be available, and the more serious the act of bad faith, the higher the punitive damages will be. Well, I think that's enough for us right now to consider these issues of third-party beneficiaries, assignment, delegation, and conditions. Next, we will consider the crucially important issues of breach of contract and defenses to breach.